Well, hello everybody, it's Joel Williams and Chase Elleby at Williams Elleby coming to you today with a brand new video where we want to talk about how to maximize the value of your case, and in order to do that you need to avoid these 10 common mistakes. So what's number one, Chase?
Number one would be believing what the adjuster tells you as far as the value of your case. I always say that insurance companies are in the business of collecting premiums and denying claims, so you can almost guarantee that the first offer they make to you is going to be less than the full value of your case.
Yeah, and they get creative about the way they phrase it too. Like they will say, we have evaluated your case and it is worth this.
Right. And that usually comes like a day or two after the wreck occurred, when you have no idea what your medical bills are, what your injuries are, or things like that.
Yep. So we call complete BS on what the insurance adjuster tells you your case is worth.
Right.
The number two mistake to avoid is going to be demanding too little or too much.
Right.
You can imagine a scenario where you go to buy a car. There's a sticker price on the car, and with the exception of anomalies in the market that we've all recently been through, you're not going to have to pay the sticker price on your car. Now, there are crazy times in this world where people pay more than sticker price on the car, which blows my mind. But when you make an offer, the adjuster is going to believe that you are willing to take less than that. So if you think your case is worth $100,000 and you're not willing to take less than that, you better demand more than that. On the flip side, if you think your case is worth $100,000 and you demand $100 million, the adjuster is going to laugh you out of the room and you're going to get nowhere in your settlement negotiation. So you want to find that sweet spot to where you're demanding more than you're willing to take, but you're not limiting yourself by demanding too little.
And you also need to know how much insurance is available. But that's
right.
Another video for another day. But generally speaking, yeah, you don't want to demand too little or too much. So the third thing to look out for is you don't want to hide from any pre-existing conditions, right? A lot of times, I mean, it just happens, right? People who are older, they'll get in a car wreck and they'll hurt their back. Well, most folks at some point might have had a back injury or some issue where they've treated with their back beforehand. And if you try to hide the ball and the insurance company finds out, which they wouldn't necessarily find out if you treated with the doctor, say 15 years ago, but if you had made another claim and had, claimed that these injuries were caused by a wreck, say 3, 4, 5 years prior to the one that you're involved in now, they will know about that and they will definitely use that against you. So you don't want to hide the ball.
Yep. Number 4 is telling the insurance adjuster that you're not the kind to sue, or you're not out for a bunch of money, or you're not trying to win the lottery. All that tells the adjuster is you're willing to settle for less than what the full value of your claim is. So even if you are the kind of person that's not out to sue, which most people aren't, don't say it to the insurance company, because one way to get them to pay full value on your case is to make them believe that you are willing to go to the mat and that you are willing to file a lawsuit and go all the way through trial if necessary. As soon as they sniff out that you're not willing to do that, your offer is going to be less.
Yeah. So number 5, kind of like hiding things, not being fully honest with the adjuster, you have to tell your attorney everything as well. You have the attorney-client relationship when you hire a lawyer, so you just need to tell them the good, the bad, the ugly about anything that could potentially impact your case. Now, a good lawyer is going to ask you questions that they're going to need to know about how to represent you in certain situations, but just because there is something that's out there, like say a prior arrest, that doesn't really mean that it's going to come to trial or that the other side's going to use it against you. They could, and you have to tell them about it, but you just have to be upfront and honest with your lawyer, because I always tell clients, like, listen, I've been doing this, Joel's been doing this long enough to where we've pretty much seen it all when it comes to things that could potentially impact your case. The thing that is always going to dive bomb your case is that if you hide the ball or you're dishonest or you lie about something, then the other side finds out, your credibility is completely gone. So that is a huge mistake.
Yep, and no case is perfect. And the problem with not telling your lawyer everything or being upfront and honest with your lawyer about the questions that they may ask you, because you may think, well, why does my lawyer need to know if I've ever been arrested, or why does my lawyer need to know this or that or whatever? Well, there's a reason they're asking him, and that's because it's going to come out, or the defense or the insurance company is going to ask you that question at some point, especially if you get into formal litigation. And if your lawyer doesn't know that this has happened, whatever the thing is, he or she's not going to know how to deal with it, or they're going to be blindsided and they're going to have to try to deal with it on the fly,
Right.
which is never going to be as good for you as if they know about it in advance and they can prepare for, and most likely things that you think might be harmful to your case or to your reputation, they can keep out of evidence. And even if it's something they can't keep out of evidence, they need to know about it so they can figure out the best way to deal with it during trial or while the case is going on.
Right.
All right,
Deflect or absorb the bad facts, right? You deflect them to get them away, or absorb them, and you have to learn how to handle them.
That's exactly right. Number 6 is going to the wrong doctor. So, believe it or not, there are bad doctors in this world, and believe it or not, there are doctors that charge you way too much money for what they should be charging you for the treatment they're giving. There's also doctors in this world that are in the pockets of the insurance company, and they're going to undertreat you and do the absolute minimum to get you by. So it's important to make sure that the doctor you go to is one that's going to charge you a fair amount, one that's going to hopefully take your health insurance to minimize your out-of-pocket expenses, and then most importantly, one that's going to treat you for the injuries that you have and not treat you according to how your case proceeds.
Exactly. No, that's a great point too. And you want to have a doctor that you trust, right? A doctor that might be a referral from a friend or family, because the doctors, they can, make or break your case.
Absolutely.
So it's very important to find a very good doctor. All right. So number 7. I always think this is a big mistake, and there's 2 pockets I guess you can go with. The first one is giving a statement to the at-fault insurance company. If you get in a car wreck, I always use car wrecks, that's the easiest example. If you get in a car wreck and the person who hit you, say, has State Farm, if a State Farm adjuster calls you and says, we can't do anything with your claim until you give us a recorded statement, false. Right? Do not give a recorded statement. You're not required to give them a recorded statement, and most of the time they're trying to take that statement to figure out a way to either deny the claim or to say, well, we understand that our insured might be at fault, but we think you're 30% at fault because you broke too hard for that yellow and red light, which caused our insured to hit you, right? So if it's the at-fault insurance company, you're not required to give them a statement, and I always tell my clients, don't give a statement, we're not giving a statement.
Yep. Another thing, not even to try to make it seem like it's not your fault, but to make it seem like you're not hurt.
Yeah.
I can't tell you how many times I've gotten a written transcript of a recorded statement where the client says something to the effect of, I'm fine.
Right.
And when they said it in the conversation, what they really meant was, I'm not catastrophically injured.
Right.
But it's normal, everyday nomenclature where we say, hey, Chase, how you doing?
Yeah, I'm fine.
Yeah.
Good. No big deal.
Yep.
Yeah, and that's it, right. And they use those words against you all the time. So it's just very important, just that as a rule, right? Don't give a recorded statement to the at-fault insurance company. Now, if it's your own insurance company, which is the uninsured motorist carrier, you're almost always required to give a statement at some point in the claim process. That doesn't mean in the first call. It doesn't mean you have to give multiple statements. It usually means that if you settle with the at-fault insurance company and you're making a claim against your own insurance company, they have a right to require that you give a statement. And that's buried pretty much in your policy language, which no one reads, that says if you're making a claim against us, it's your contractual obligation to help us in investigating your claim, and that almost always includes a recorded statement. And when we do the recorded statements, we're with our clients on the phone to make sure they're kind of staying in bounds with the questions that they ask.
Yeah, hopefully if you do give that recorded statement, you're doing it with your lawyer present.
Yep.
Number 8 is hiring the wrong lawyer. Just like there's good and bad doctors in the world, there's good and bad lawyers in the world. And there are some good lawyers whose business model prevents them from maximizing the value of your case. I would just say this, be very wary of mass advertisers and the attorneys that you see on television and billboards all the time, because they have thousands and thousands and thousands of cases. And they will say, we have this army of lawyers behind you, and all of that. They may have an army of lawyers, but they also have an army of clients that the lawyers have to represent. So one lawyer cannot effectively handle 1,000 cases and try to maximize the value of each one of them. It's just not possible. Now, you can have support staff and all of that, but if you want to maximize your case, you need to know that insurance companies keep track of personal injury lawyers and their firms, and they know which ones settle cases for less than full value and which ones demand maximum value for the case. So don't fall prey to the advertising cliches and the advertising gimmicks, thinking you're getting the best lawyer in the world when you're really never going to see the lawyer in person or talk to the lawyer on the phone that's on the billboard or the television commercial.
That's right. All right, so number 9 is, like we talked about, prior injuries, subsequent injuries, or injuries that happen after a car wreck or after a slip and fall. If you try to cover those up or try to kind of sweep them under the rug, it's a big no-no. And again, it goes back to credibility, for one. And also, two, the insurance companies, they're going to find out about it, right? If you file the lawsuit, they're going to send discovery. The discovery is going to ask for any and all doctors you've ever treated with. And you're going to list those doctors. They're going to read those medical records, and they're going to say, oh, hey, John Smith, remember when we asked if you were in a wreck either before or after this wreck? Well, you didn't tell us about this wreck or this doctor you treated with 6 months after this wreck that said you injured your back just like you did in this one, right? So it's all about credibility. You got to be upfront and honest, not only with your lawyers, but also with your doctors and also with opposing counsel, because that's how you fairly can evaluate your case and your claim to the jury.
Yeah, and even if it's an injury to a different part of your body,
Right.
if you're in a subsequent wreck or fall or anything like that, you may think to yourself, why is it relevant to this case when I hurt my neck in the case that you represent me for, Chase, but I got in another wreck and I hurt my knee?
Right.
Well, if you don't disclose the next wreck, then the defense attorney or the other side's insurance will be able to make a good argument then, well, if you didn't hurt your neck in the second wreck, like, why is it a big deal? Like, why didn't you just tell us about it?
Right.
You know, or why are you trying to cover the wreck up if it doesn't have anything to do with this one, right?
Yeah, it's credibility.
So just credibility and honesty is always key. Speaking of honesty, number 10 is not being honest with yourself about the severity of your injuries. So often we get clients that come in and they say, it's not that bad, I'm okay, I'm just gonna suck it up, I don't want to go to the doctor, I don't want to get therapy, I don't want to, risk having to have a surgery, I don't want to stay out of work. And then the injury gets worse because you don't get the medical treatment
Right.
you need, or you try to get back into work too soon, or whatever. But you have to be honest with yourself about how bad your injury is and not sweep it under the rug, because if you don't get the treatment you need to get better, then it's not only going to hurt your body, it's going to hurt your case, because at least in Georgia, you have a duty to mitigate your damages, which means doing everything that you can do to try to get better.
Yeah, and that's exactly right. A good example I like to say is, some people might go to the doctor and the orthopedist might say, hey, Joel, your knee's been bothering you because of that wreck. Well, you need to do 6 weeks of physical therapy. Clients might be like, well, no, I'm fine. I'll do therapy at the house. It's not a big deal. And you don't really do it that much, or you do it a little bit, but you don't do what the doctor tells you to do. Well, you can't 6 months later say, well, my knee's still bothering me, because they're going to say, well, what about that therapy the doctor told you to go to, and you ended up not doing it. So you have to mitigate your damages. Always go to the doctor, always get checked out, do the treatment that they say, and if you don't need it and you're fine, great. If you do need it, just do it.
That's right. All right, those are the top 10 mistakes we normally see that hurt settlement values. So avoid them at all costs. And if this video has been helpful to you, give us a thumbs up. Hit that subscribe button. Otherwise, we will see you next week, where we will talk about what to expect during a consultation with a personal injury attorney.